I think we can all agree, right? We all want to fight hate and extremism. So when a new law comes along with that exact goal, it seems like a no-brainer. But what if the tool we build to do that is, well, a bit like a sledgehammer, when what you really need is a scalpel?
And that's the wild question at the center of this whole explainer. I know, it sounds completely out there, a law meant for neo-Nazis that could also apply to a police force. But this gets to the very heart of the debate around this proposed hate and extremism bill. And the key thing to remember is this. The question isn't whether the government would do it, is whether the law as it's written could let them.
So let's start with the goal, the Combatting Antisemitism, Hate and Extremism Bill. I mean, the name says it all. The intention here is solid, something pretty much everyone supports, giving the government some real teeth to take on groups that push violent, hateful ideas. And the main tool it uses? Well, it's a big one. The bill basically gives the government the power to just list an organization as a prohibited hate group. And once you're on that list, you're effectively outlawed. This isn't just a slap on the wrist. We're talking about a complete legal shutdown.
All right, so let's get into the nitty-gritty here. How does a group actually end up on this list? What's the process? Well, it all comes down to a set of criteria that the minister has to be satisfied are met.
Okay, so the first big trigger is if a group has engaged in a hate crime. But here's where it gets really interesting. The way the bill defines hate crime is, well, it's huge. It can include actions that caused serious harm based on race, even if those actions happened decades ago and weren't even illegal back then. Yeah, you heard that right. It's retrospective.
And get this, and this is a really crucial detail. A group can be put on this list without ever being charged with the crime, let alone convicted. The minister just needs to be satisfied on reasonable grounds based on, things like official reports or public inquiries. So the bar for evidence, it's a lot lower than you might think.
So this is where legal analysts start to raise some red flags. And what's so fascinating is that the potential dangers they see don't really come from assuming anyone has bad intentions. Nope. The problem, they argue, is baked right into the fundamental design of the bill itself.
So what are these flaws? Well, they all kind of link together. First, the definition of an organization is super broad. It covers everything, and there's no special carve-out for government bodies. Then you've got that retrospective hate crime trigger we just talked about. And on top of that, there's no requirement for what's called procedural fairness, which means a group could be listed without ever getting a chance to defend itself in a hearing.
There's actually a fantastic metaphor in the source material that explains this perfectly. The law is described as being like a fire suppression system, but one that can't tell the difference between the controlled heat of a forge and a raging wildfire. See, it just detects heat, any heat, and floods everything. It can't distinguish between a real extremist threat and maybe an institution that's grappling with its own past and trying to fix things.
So to really test the limits of this law, to see just how wide that net can be cast, some legal scholars ran a thought experiment. It's a classic reductio ad absurdum, which is just a fancy way of saying they pushed the logic to its extreme conclusion. They took the literal text of the law and applied it to a completely unexpected subject, the Victoria police force. And again, let's be super clear. The point isn't that this would ever happen. The point is to see if the law's own language could let it happen.
And where do they get the evidence for this thought experiment? Well, it comes directly from Victoria Police's own public statements. Back in 2023, the Chief Commissioner made this really powerful, unreserved apology, acknowledging a history of police actions that caused trauma and harm, particularly to Indigenous communities.
And this table, wow, it just lays the argument out so clearly. You just map the bill's own criteria against the public record, and a really startling picture starts to form. So, Criterion 1. Has the organization engaged in hate crime conduct? Well, they've officially admitted to systemic racism that caused serious harm and trauma. Check. Criterion 2. Has it advocated for it? Well, reports found that some internal training materials actually praised racist historical practices. So, check. And what about the last one? Is listing necessary to prevent harm? The police leadership itself has said that some of their practices continue to cause harm. So if you just read the law literally, you can see how someone could argue that the criteria are met. It's pretty shocking when you see it like that.
Okay, so what if this did happen? What are the actual consequences of getting put on this list? They're not small. In fact, the source material calls it a legal death sentence.
For starters, if you're a manager or a leader, anyone intentionally directing the group's activities, you could be looking at up to 15 years in prison. 15 years.
And it's not just the people at the top. Just being a member, if you know the group is on the list, could land you in prison for up to 7 years.
Basically, getting listed criminalizes the day-to-day running of any organization. Think about it. Paying your staff? That could be seen as criminal funding.
Hiring someone new? That's criminal recruitment. Even running a simple training session could become a criminal act. Any support of any kind is outlawed. The organization is just legally paralyzed. It can't function.
So let's zoom out for a second. What's the bigger picture here? This isn't just about one hypothetical scenario. It's about a much broader lesson in how we design our laws and the principles behind them.
Okay, so you might be thinking, wait, isn't there a defense for people like police officers? And yes, the bill does have an official duty defense, but here's the catch, and it's a big one. That defense is for an individual person, after they've already been charged. It's a shield you can use in court. But it does absolutely nothing to stop the organization itself, the entire police force in this example, from being put on the list and effectively destroyed in the first place.
And that brings us to the most crucial point of this whole explainer. The problem isn't about accusing anyone in government of acting in bad faith. It's about bad design. The law, as it's written, is missing what legal experts call an internal limiting principle. It's missing that crucial bit of code that would allow it to tell the difference between a public institution trying to reform and a hate group that needs to be shut down. It just lumps them all into the same legal category.
And all of this leaves us with a really fundamental question, one that goes way beyond just this one bill. When we're trying to solve a problem as serious and as important as hate and extremism, how do we make sure the laws we create are powerful enough to actually work, but also precise enough that they don't cause huge, unintended damage? Finding that balance, well, that's one of the toughest challenges for any democracy.